Yeah, well, you know, I was judging NFL months ago, and a lot of it is convincing them not to really be NFL competition. So I guess they're just more independent.
Okay. Good morning. Well.
On behalf of the Office of the Attorney General of the Commonwealth of the Northern Mariana Islands, I would like to welcome everyone to the 17th Annual Attorney General's Cup Speech Competition. I would now like to ask Father Bradley to join us with the invitation.
For we know that you are the source of everything that is good. And we ask your Spirit on this contest, on the participants, the judges, and all of us here present. We thank you for bringing us together, and we praise you for that. For we know that nothing is by chance in this world, but it is guided by you and your Spirit. Father, we pray for these students this morning. We pray that you may instill in them a spirit of loving service to their government and to their neighbor. We pray that you may give them the spirit of striving for excellence in a world that is satisfied with much less. We ask you to give them joy in the hope that they will be good citizens this morning. We ask to give them patience and understanding in trials that only few will be chosen as winners. But most of them keep them faithful. As Christians, believers, members of this community, Father, we ask your blessing now on this whole day. May it only be filled with good things in your name, for you are the source of goodness, through Christ our Lord. Amen.
Ask to lead us in the national anthem for the Commonwealth of the Northern Mariana.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous flight o'er the ramparts we watched were so gallantly speeding, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet
office to make some opening remarks and introduce the contestants and judges.
Good morning, everybody. It's my pleasure to welcome you all to the 17th Annual Attorney General's Cup. Attorney General Herb Soule could not be here today because, as many of you know, his confirmation hearing, or a public hearing on his confirmation, is being held in about 2 hours on Tinian. But he asked that I extend his best wishes to the participants and the guests. I'd like to acknowledge our judges this morning. We have William R. Barano, Executive Director of the NMI Council for the Humanities, Nancy J. Gottfried, the Assistant Attorney General, Bertha C. Leon Guerrero, Director of the Division of Public Lands, the Honorable Juan T. Lizama, Associate Judge of the Commonwealth Superior Court, and the Honorable Alex R. Munson, Chief Judge of the U.S. District Court. We also have a number of dignitaries with us this morning. I'd like to acknowledge the Honorable Pedro Tenorio, Governor of the CNMI, and the Honorable Oscar M. Babauta, Floor Leader, who's representing the Speaker today, the Honorable Antonio M. Camacho, the Honorable Benjamin Manglonia, Mayor of Rota. We have Mr. Joaquin Sablan, President of the NMC, Juliana Sandvold, who is here on behalf of Jesus Sablan, the Lieutenant Governor, the Honorable Gregorio Guerrero, Chairman of SAIPAN Northern Islands, the Honorable David Indalecio, Vice Chairman of the Municipal Council, the Honorable Miguel S. Demapan, Chief Justice of the Supreme Court, former Lieutenant Governor Jesus Borja, and I don't see him on the list, but I recognize Representative Stanley Torres here this morning as well. Welcome, one and all. Another person whose absence is keenly felt today is Justice Villagomez. He's been a great supporter of the Attorney General's Cup in years past. I spoke with the Executive Director of the Bar Association this morning, and she says that he is now awake and he is doing much better, and I know that we all hope that he'll be with us next year. This year's topic was chosen because it is timely and controversial. The policy choices made in resolving this issue are sure to affect the future of the Commonwealth. Just as previous participants and winners in the Attorney General's Cup are all serving the community in distinguished fashion, there is every reason to believe that this year's participants will, in the years to come, be important contributors in the arts, medicine, law, politics, and other fields. Now it's my pleasure to introduce this year's participants in the Attorney General's Cup. From Northern Marianas Academy, Erica Aktoka. From Grace Christian Academy, Ryan Jonathan Camacho. From Marianas High School, Carmen Indalecio. From Marianas Baptist Academy, Paul Murphy. And from Mount Carmel High School, Nathan Sablan. Thank you all for coming this morning, and good luck to the participants.
Thank you, Jim. Now we need to find out the order in which the speakers will be presenting their speeches this morning. To do that, I have placed each of their names in the Attorney General's Cup. He couldn't be here this morning, he gave us his cup. So we have the Attorney General's Cup here, and I'd like to ask Governor Tenorio to pick the names out for the order. The first speaker will be Carmen Indalecio. will be Ryan Camacho. The third speaker will be Paul Murphy. Erica Actofa will be fourth speaker. And who could it be? The fifth speaker will be Nathan Sablat. So I would like now to invite Carmen up to speak with us. Thank you.
I've got one thing for the speakers. I'm sorry, Carmen and the speakers. Our timekeeper will give you a card when you have 5 minutes left, a card at 3 minutes, and a card at 1 minute, and a stop card. You have to stop when she shows you the stop card, or I'll go and plug the mic. Okay?
Ladies, gentlemen, judges, Hoffaday, and good morning. My name is Carmen Marie Indalecio. I have a history. My family has a history. My father is Chamorro Carolingian. My mother is French-Canadian. Both are proud Americans. I am proud of who I am, and I am proud of the entire range of my cultural heritage. Additionally, I believe in fairness, equality, and justice. Finally, I am very much interested in seeing that the future of this Commonwealth remains bright. March 17th, 1998, Thomas P. Villagomez, Ricardo S. Atelig, Juan P. Tenorio, all CNMI senators introduced for Senate consideration Legislative Initiative 11-1. This initiative proposed a constitutional amendment to amend Article 18, Section 5, to provide that only persons of Northern Marianas descent might vote on amendments related to matters of land alienation. This initiative passed the Senate on November 13, 1998, and the House 7 months later on June 24, 1999. Initiatives must be ratified by the people, so on November 6th of last year, that hurdle too was overcome. The initiative was ratified by a vote of the people, 6,124 to 4,960. Today, I come here in the hope that I might convince you judges and those here present that the legislative passage of Initiative 11-1 and its subsequent ratification by the people at large is fair, reasonable, and a vital element in the preservation of our local culture. I also seek to demonstrate that Rice versus Cayetano of Hawaii does in no way mitigate the legality or the applicability of the provisions in this initiative. I contend that this new public law is fair, and more, that it is fair to indigenous and non-indigenous citizens of the CNMI. Fair, Webster's unabridged, just, honest, impartial, unprejudiced, with evidence gleaned from the Constitution and the covenant of the CNMI. I shall show that Public Law 11-1 is all of these. June 17, 1975. 78.8% of eligible CNMI voters approved the covenant with the United States of America. The results of the plebiscite were recorded, and the covenant document was ratified by the United States Legislature and signed by then President Gerald Ford on March 24, 1976. These actions, according to Section 101 of the covenant, place the CNMI, quote, in political union with and under the sovereignty of the United States of America. This was a historical milestone in the evolution of the CNMI. This was a special moment. It is a special document. Contained within that document, that very special document, is Section 805. Section 805 gives the CNMI local government the authority to regulate and limit land acquisition to those of Marianas descent. Again, this was ratified by the United States legislature. Again, this was signed by the President of the United States. And it was enacted not to protect one race and disenfranchise another, but to prevent the likelihood of exploitation by foreign interests. And there can be no injustice in that. Now, in September of 1983, after long deliberation and hard work, the CNMI Constitution came into effect. Within it was Article 12. Article 12 implemented the intent of Covenant Section 805 against land alienation. In a letter to the SAIPAN Tribune entitled Fair Exchange, former associate of the CNMI Supreme Court Justice Ramon Villagomez wrote that the purpose of Article 12 and Covenant Section 805 were and remain to protect the people of the CNMI from the loss of their land. The covenant protects them from being overwhelmed by aliens, by foreigners who come to our shores and subsequently become United States citizens who may consume the land. Now, the CNMI Covenant and the Constitution established that NMI land belonged to the indigenous people. The passage of Public Law 11-1 merely ensured that those who own the land make decisions concerning the land. Logic? Yes. But there are those who disagree. Let us analyze some of their arguments. Let me clarify some of the widely held misconceptions besetting this topic. First, the argument that holds that Public Law 11-1 violates the 14th and 15th Amendments of the United States Constitution is errant. It is errant, that is, unless Congress and the Chief Executive of the United States are powerless to effect treaties or to sign binding covenants. Clearly, these are not powerless. In fact, the United States Constitution guarantees their authority, even their responsibility to enact such documents. They passed and signed ours. Now, it is understandable that some may always be found who find any regulations or any restrictions that are culturally or racially motivated to be questionable, even evil. But in the singular case of Public Law 11-1, such thinking is not justified. It was not enacted to restrict the rights of other races, but to preserve a culture, a way of life, and it is duly signed and enabled by the United States legislature and by their chief executive. It is not a matter of money. It is a matter of cultural preservation, and only that. Second, the argument that the indigenous people of the CNMI can buy land and vote on land in the United States, but that stateside Americans cannot buy land, and now by the passage of Public Law 11-1 cannot vote on land issues in the NMI, is not to be taken seriously. The scores 3.5 million to 176 square miles, that is. Now, we're not even talking the same game. NMI land is as scarce as hope for indigenous culture if local control is lost. And it must not be lost to ill-considered or unrelated precedents, such as Rice versus Cayetano of Hawaii. Which brings me to my third argument. That the passage of Public Law 11-1 is an invitation for what happened with Rice versus Cayetano to happen here in the CNMI. Clearly, ladies and gentlemen, this is not the case. Now, in reality, the basis of the two disputes are unrelated. The composition of the Hawaiian Commission that brought about the United States court case was something that was not previously agreed to by the United States legislature or their chief executive. It was a local ordinance of Hawaii. But the United States legislature and their chief executive did agree to our covenant and to our Constitution. In this difference alone resides strength and unassailability in our special document. Ladies and gentlemen, the case is simple. Public Law 11-1, amending Article 18, Section 5, does no injury to the United States Constitution or to its people. It is not unfair to foreigners who come to our shores and subsequently become United States citizens. It is fair, it is perhaps even generous to the indigenous people of the Sinai. And there is nothing evil about any of that. Now, cultural preservation is an important American principle in this latter age. The passage of Public Law 11-1 ensures that the future of the Commonwealth of the Northern Mariana Islands remains bright, and that the indigenous people of these islands, already outnumbered, may retain the birthright to land held so dear by them. Ladies and gentlemen, I hope that I have been convincing. I hope that I have clarified some of the widely held misconceptions. My name is Carmen Marie Indalecio. I am proud of who I am, and I am proud of the broad spectrum of my cultural heritage. Thank you, Mr. Monsieur.
Carmen, thank you very, very much. I'm going to give the judges just a few minutes here to write down their scores and some of their comments. Are the judges ready? Okay. Our next speaker is Ryan Jonathan Camacho, from Grace Christian Academy.
Buenos dias, Governor Tenorio, judges, ladies and gentlemen. Recently, the Commonwealth passed a constitutional amendment to amend Article 18, Section 5 of the CNMI Constitution. This provides that only persons of Northern Marianas descent can vote on constitutional amendments affecting the protections against alienation of land in Article 12 of the Constitution. I stand here this morning in favor of this law because of the following reasons. 1, it does not oppose the U.S. Constitution. 2, it is fair to the indigenous people. And 3, it is not unfair to the non-indigenous people. My first argument upholding the constitutionality of the law is that the voting right is based on ancestry and not on race. According to Justice Stevens in the Rice versus Cayetano case, the distinction between ancestry and race is more than simply one of plain language. The ability to trace one's ancestry to a particular progenitor at a single distant point may convey no information about one's own identification with a particular race, or the exclusion of any others on account of race. The terms manifestly carry distinct meanings, and ancestry was not included by the framers in the amendment's prohibitions, end quote. Determining whether a person is of NMI descent is not racially or ethnically based, but it is based on identifying with those persons who chose to make the NMI their home and who acquired trust territory citizenship as of 1950. It is not discriminating anyone because of their race or nationality, but rather limiting the voters to those who are descendants of the people whom the provision of the covenant pertains to. The Office of Hawaiian Affairs, likewise, limited the classification of eligible voters in electing its Board of Trustees to, quote, ensure that regardless how dilute the race of Native Hawaiians become, there will remain a voting interest whose ancestors were a part of a political, cultural community, and who have inherited through participation and memory the set of traditions the trust seeks to protect. Unfortunately, the Supreme Court did not uphold that provision for Hawaii. But on the other hand, due to the special relationship we have with the U.S. explicitly described in the covenant, specifically Article 8 regarding land, we must pursue the same course taken by the Office of Hawaiian Affairs regarding its voters, because it further protects our right to the land and does not violate the Constitution. And then there is Section 805 of the Covenant, which assures that the people of the Northern Marianas will be able to retain the ownership of the land, their most precious asset, in order to protect their culture and traditions, as well as to protect them from exploitation and to promote the economic advancement and self-sufficiency. The people of the Northern Marianas will be able to uphold the alienation of their land, notwithstanding any other article of the covenant or any provision of the Constitution or treaties or laws of the United States applicable to the Northern Marianas. I repeat, notwithstanding any treaties or laws of the United States. And after the expiration of the stipulated 25-year period, the government of the Northern Mariana Islands may regulate the alienation of property as described. The gift of land was given to the Chamorros and Carolinians, and it is their responsibility to take care of it and utilize it for the betterment of the CNMI. Therefore, those who are not of NMI descent have no just cause to determine what to do with this precious asset. In the year 2011, Article 12 will be discussed and voted upon. Let it be to the owners of the land to decide what to do with this. By only selecting those of NMI descent, those of whom the land belongs to to vote on such an important, delicate issue is a proper move and in accordance with the covenant. Now there's this also concept of beneficiary and trustee. Who are the beneficiaries of the land? It is the indigenous people who are the beneficiaries, and it is they who are the trustees as well. Land was given to them. It is theirs to use and theirs to decide upon. The Constitution, specifically Article 12, helps to protect the land. The government drafted the voting qualification because people to whom the assets belong should have control over them and the decisions affecting them. This new law will enhance government and decision-making accountability, and as a result, strengthen the relationship between the Chamorros and Carolinians as beneficiaries and as trustees, with the Constitution as a safeguard. The alienation of land is for the benefit of those of Northern Marianas descent, and those who are interested parties of Article 12 would be the best way to ensure proper management and adherence to the needed fiduciary principles. I quote from the United States versus Kagama case. These Indian tribes are the wards of the nation. They are communities dependent on the United States, dependent largely for their daily food, dependent for their political rights. From their very weaknesses and helplessness, so largely due to the course of dealing with the federal government with them and the treaties in which it has been recognized by the executive branch and Congress, end quote. The people of the Marianas, including myself, are similar to those Indian tribes. Are we not somewhat dependent on the United States? Do we not deal with the federal government? Is not our covenant recognized by the executive branch and Congress? By signing the covenant with us, the United States entered a special political relationship with us, similar to the special relationship they have with the Indian tribes. Congress went through such lengths to protect the interests of the Indian tribes because of their special obligations to them. Likewise, the U.S. has a special obligation to us. If she didn't, then why even emphasize that no U.S. law shall abridge the people of the CNMI's exclusive right to own land? That alienation in itself may be considered unconstitutional, yet it is not, because of the said emphasis on the covenant. We are a minority, and we have as much right to decisions of the land as the Indians. After all, land ownership is a physical manifestation of land, a claim of ours to local self-government. All our land are indigenous. It is fair for the indigenous people to for the non-indigenous people because the land indigenous of those